Court calls case, People versus Michael T.
Emotions are calm, but the stakes are high. The case, People versus Michael T., moves forward as the defense and prosecution discuss multiple assault charges. Missing witnesses, dismissed counts, and legal waivers set the stage for a tense but procedural battle. Watch closely as the judge carefully walks both sides through a maze of legal details and warnings that could change everything for the defendant.
Good morning, Your Honor. I'm Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Mr. T. Mr. T, can you state your name for the record?
Michael T. Thank you. He's waving.
Yes, Your Honor. And there's, yes.
Your Honor.
Can I stop you? No, go ahead.
I would stop Your Honor.
No, you wouldn't. Go ahead.
Your Honor, as I indicated to the defense counsel this morning, while we are missing an important witness, this is a case where we would ask the court to be able to proceed under 768-27C as well as People versus only on most of the counts. So, Your Honor, if I may go through count 1, we would be able to proceed in such manner if the court allowed. Count 2 as well. Count 3, we would not be able to proceed today. So I'm sure counsel is going to ask for dismissal of that count. Count 4 and 5 are misdemeanors, so we would ask that those follow counts 1 and 2. Your Honor, that would have been our intent today, is to proceed under that authority. And my understanding is that the defendant's going to waive on those counts.
So, just so that I'm clear, he's waiving on 1 and 2, 3 is being dismissed, and 4 and 5 are following.
I thought one was being dismissed.
I'm sorry?
I thought one was being dismissed.
I'm sorry. Yes, Your Honor. Thank you. Count 1, Your Honor, even though we would be able to proceed if the court allowed under People versus Old Main statute cited, we would agree to this.
All right. So you're going to waive, he's waiving on count 2 with 4 and 5 following, right? Okay.
Yes, Judge, that would be correct. And if...
The courtroom opens with confusion. The prosecutor explains that one key witness is missing, yet the state wants to proceed under a special statute. The judge listens intently as both sides debate which charges can move forward. One count gets dismissed, another continues, and 2 misdemeanors are added to follow. It's a complicated legal dance. One misstep could change the entire outcome of the case.
If I could, I do
Yes,
need to...
go ahead.
So my client and I, Mr. Teague and I, have discussed this. It's my understanding that he does understand that the people could proceed under the court rule on the assault with intent to do great bodily harm charge, the felonious assault, and the count 2 felonious assault, and that after full discussions that he is intending to waive his right to an exam. In exchange, the people would dismiss count 1, assault with intent to do great bodily harm. So the waiver would be with regards to count 2, felonious assault. We, the defense, would be moving for dismissal of count 3, felonious assault, as the people are unable to proceed on that charge. The 2 misdemeanors, of course, I've explained to him he does not have a right to have an exam in those matters, so those matters would follow. Is that correct, Mr. Teague?
Yes. Next, defense attorney Christina Costantino takes the floor. She confirms that her client, Michael T., understands his rights, and that he's choosing to waive his preliminary examination in exchange for a dismissal on the most serious charge. It's a tactical move, sacrifice a hearing now to secure a lighter path forward. The courtroom quiets as Michael simply answers, "Yes, sir," to every question from the judge. Calm, controlled, but you can feel the pressure behind each word.
Yes. All right. You had an opportunity to have a full and fair discussion with your attorney regarding that. All right. Sir, along those terms, you're willing to waive your right to have a preliminary examination? Sure. Yes?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit on counts 2 and the misdemeanors following?
Yes, sir.
You understand that, sir?
Yes, sir.
People also waive their right?
Yeah.
All right. Preliminary examination having been waived, defendant is bound over to circuit court on count 2 with 4 and 5 following.
Your Honor, with regards to the information, we would stand mute and waive a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to counts 2, 4, and 5. Counts 1 and 3 being dismissed. Pretrial in this matter will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30 before Judge Slay.
Your Honor, if I may address one other thing.
Yes.
Your Honor, I want to make sure that at this point it would essentially just be a warning or request from the court to defendant to make sure there's no contact with the victim. We also want to make sure that he understands that applies to other third parties.
All right.
And Your Honor, my client and I have discussed that today. He is aware, of course, of the no contact order. We've discussed. Sorry, got distracted by Officer Allen. Judge, we have just.
Got your feeling.
Yeah, it happens. We've discussed the no contact order. He understands that he cannot have contact not only with the complainant, but third parties, intending that contact to get back to or involve the complainant. So we have discussed that. It's my understanding he is aware of that. Is that correct, Mr. Teague?
Yes, ma'am.
All right. So, sir, you understand all of those terms in terms of the no contact.
It's no contact. It's no contact.
That's it. No contact. That means even through third parties. I will give you this ammunition. I'm sure she wouldn't care. You don't want that issue if it arises coming before me. I will tell you that Judge Slay does not tolerate that at all. So I'd suggest that you follow the advice of your counsel and make sure none of that occurs. Understood?
Yes, sir.
All right. Bond will continue.
Thank you very much, Judge. Have a good rest of your day.
It'll never end.
With the legal formalities done, the prosecutor raises one final concern, a no-contact order with the victim. The judge steps in firmly. No contact means no contact, not even through third parties. His tone sharpens as he warns the defendant that violating the order could land him right back in court. Even the defense attorney nods seriously. It's a moment that reminds everyone, one wrong move outside the courtroom could destroy everything agreed upon inside it.